Hello.
Richard can't get in.
Really? He tried using that link in the calendar invite.
Hold on, I think he's calling me. This is Jasmine. Hey, I just saw your email. So your invite was sent a few days ago to your rjulia@archerlaw email address. Is there a different email address we should send something to? I did it for you. I registered and approved you, I think, a week ago. Yeah. Sure. Is your Zoom account tied to rjulia@archerlaw.com or a different account? That's the only way I could see a problem. Okay, well, do you want me to try the home one and we can just double check? Yeah, because I approved you days ago, yeah. I've done it already, that's the thing. I've done it days ago and I can't re-register you because I've already done it with your Archer account. Like it's already been processed twice.
I can try resending him a confirmation.
Let me go in right now, and I just approved it, so you should get an email in a second. You should have, did you also gotten one to your Archer email? Perhaps that might work. Yeah, sometimes if the Zoom account isn't tied to the same email that was approved, it doesn't work. You're in. Is it bringing you into the waiting room? All right, I'm letting you in right now, and I had a waiting room. All right, there you are. I had a waiting room set up so we could let you in first. All right, I'm gonna hang up here.
With computer audio, it should work.
You're good. I hear you.
All right.
All right. This is why we do a waiting room, because we let.
No, I'm not getting the audio. Hi, Anna. How are you?
I'm good. How are you?
All right, we can all hear each other.
Yes.
All right. So I'm gonna let the people in the waiting room go. Glad that we got this sorted out.
That was easy. Boy, we can solve that problem in 5 seconds.
I'm sorry that we had it. I thought I was on top of it by sending it to your Archer email.
I don't understand. I don't understand that.
No worries. All right, there's a couple people in the waiting room. I'm gonna admit them. We have about 40 people registered, so I might give it a few extra minutes to let people trickle in. But I'm gonna let these folks in, do a tiny bit of an intro, and then I'm just gonna let you do your thing, and if I can be helpful in moderating questions, great, but we're like gonna let you run it.
All right.
Best if you're comfortable with that.
Now, the only thing is I want to share my screen at some point, that's all.
So you can do share screen at the bottom of the Zoom window. It's just like the share screen window. When you click that, you'll have the slides, or if you prefer, it's only 3 slides, so I can share them too if you want. You can just tell me when to go next. But
is this working?
yeah, just click that and go into like preview mode or presenting mode, whatever you need to do.
All right.
And then
All right, so that you can see that now?
Yeah.
All right.
Go into like presentation mode so we don't have to, so we can see it like clear. That would be great. If not, this is fine too.
You're talking about this?
Yeah, perfect.
All right, well, I'll stop the share for now, I guess.
Yeah, I'll do a quick
Right.
little intro. I'm gonna let folks in now, and we'll let a few more trickle in. And maybe as people join, you can just put something in the chat periodically to be like, hey, we're gonna go over a little presentation, then we'll get to the Q&A. And we'll go from there.
Great.
Cool. All right. Well, for those of you that have just entered, welcome to our second Small Business Owners and Entrepreneurs Forum. Good to see you all. I hope some of you will also continue to come on screen during the discussion so we can have a bit of Q&A for Richard here. I'm going to let things trickle in a little bit. There was about 40 people that registered for today's forum, so I want to give them all a chance to hear, especially the educational presentation that you have prepared, but also the Q&A. But before we do that, because I don't want to make you introduce yourself twice, Richard, I'm going to give the TechUnited spiel, because everyone has probably already heard that, and we don't have to waste any more time with that one. So I'm Jasmine. I'm the head of experience from TechUnited. Very excited to have Richard here with us today, who's going to be talking all about IP and patents. This is our time for Q&A, for education, for connecting with fellow members. Richard's a member of our advisory board as well, so we're doubly excited to have him here with us today. We've got an hour on the books to learn a little bit and ask some questions. This is being recorded, so if you want to share it or rewatch it afterwards, you're more than welcome to. We'll be sharing the link post-event. And of course, you know, if you are interested in any of our upcoming forums or TechUnited events, they're all available at techunited.co. And I'm sure you've all been getting emails from Anna and I about what's been going on, and there's a lot going on, so stay tuned. For now, the waiting room is still clear. I'm going to let people in as they join, but I'm going to turn it right over to you, Richard, and thank you again for joining us today.
All right, great. Thank you, Jasmine, for the wonderful introduction. Very happy to be here. Always happy to work with New Jersey Tech Council, now known as TechUnited New Jersey. Excited about the new direction. Saw some of the great Propellify speakers that were announced. Looking forward to that as well. And I guess part of Propellify and part of what, I mean, the lifeblood of TechUnited New Jersey is how best to develop technologies, and my specialty is advising on how to protect those developments, and I've been doing it for 25 plus years at the law firm of Archer and Griner. We've got a lot of offices in New Jersey, I think about 10. I'm in the Philadelphia office, but I'm often called upon to travel in parts of New Jersey and meet with clients to review their developments. And this is a lot of what I do is work with startups and what I call emerging growth companies, and they have their own particular needs. I prepared just a very short presentation to level set everybody. Some of you might find it, old hat. Some of you might find it of interest. The point, though, is, I guess, to give us some food for thought, and then let's take your questions for, the second part of the discussion here. I'm now going to.
Cool. Sounds good. And just so everyone knows, I think if I'm going to probably go on mute myself, just so we can all hear Richard super clearly. Obviously, I hope that many of you will come back on audio and video for the Q&A portion too. Richard, I'm going to turn it over.
All right. All right. So can everyone see the charts now?
Yep.
All right, great. So, let's start with a little bit of bread and butter here. What the importance of intellectual property to emerging growth companies. There's a lot of reasons to consider investing time and energy in intellectual property in its broadest sense. It instills investor confidence at all stages of growth. It gives a sort of a line in the sand, a benchmark of what has been achieved in terms of thought, energy, and intellectual energy, especially to have a product that's covered by intellectual property, to have a process, methods, services. To the extent you can acquire some tangible, or I guess in this case intangible, intellectual property around those, it instills investor confidence. It is an intangible asset. It becomes a company asset. It's an asset on the books. It has a valuation. Of course, it helps differentiate your products and services from competitors, either by your associating your company name or brand with the products or services in the form of a trademark, or by saying that your product or service was so new and so not obvious from what's gone before that it merited the award of a patent. That's a very nice market differentiator. Even being able to say patent pending during the long process that a patent is pending might have value in the marketplace, and tends to alert competitors to be careful if your competitors are thinking of copying what you're doing. So it has that value. And then another benefit which is sometimes overlooked, is while you're busy developing one geographic or product segment or market segment, if your development has application to other markets geographically or other fields of use, a patent that covers that, even if you're not exploiting it yourself, could be the subject of an independent revenue stream by you licensing that development to others. And it allows a diversity to your company's growth. And again, all helps with the company valuation, investor confidence, and the assets that you have as an emerging growth company. Now, let's see if we can go to the next slide here. Maybe I can't. Okay. Types of intellectual property. And more importantly, what are the pros and cons of the different types of intellectual property? Here I've listed out 5 different types. Trade secrets is a form of intellectual property. It's particularly appropriate when you have developed a confidential formula, a Coke recipe or some other interesting formula. If there's a business or manufacturing process which really has value and or technique, a management technique, a software technique. The key of the trade secrets is that they must be capable of remaining confidential. So if the formula or the process becomes readily apparent to customers, that's a con of trade secrets. You shouldn't really rely on trade secret protection because it won't last very long. One of the pros of trade secrets is that it doesn't require a lot of legal investment to protect it. It's protected by virtue of you're just keeping it confidential. A lot of times companies will wrestle with the idea of, do I keep something a trade secret because it's an interesting process, or do I try to patent that process? It depends on the particulars, and that's the sort of thing we advise clients on. Trademarks doesn't relate to inventions per se, but it relates to brands that are used in commerce. It could be your company's trade name. It can be particular products. Trademarks can be very valuable. If you develop a following, people will ask for your product or service by mark, regardless of whether there's an underlying patent on the product or an underlying patent on the services. The trademark has the advantage of lasting forever. Some of the oldest trademarks relate to, I think, ales in England, like Bass Ale, I think is one of the oldest. The red triangle of Bass Ale. I don't know if you have any Bass Ale drinkers here. I think that's one of the oldest trademarks in the world. Patents expire. Trade secrets can become non-confidential. Trademarks, as long as you're using the mark in commerce, they last forever. Copyrights, you're familiar with it. They tend to relate more to artistic expressions. They do cover software. They are more limited in their coverage because it really is the way the software has been written, perhaps its structure, sequence, or organization. The disadvantage of copyright is, in order to infringe a copyright or enforce your copyright, the infringer really needs to have accessed the copyright and substantially copied the software or the artistic expression. The pro of copyright is that it's relatively inexpensive to register it. All right, very quickly, 2 more types of patents I wanted to talk to you. 2 more types of intellectual property in the form of patents. One is a design patent. It's often overlooked, but if you have a product that really has value because of its industrial design, it's just a great shape or an interesting design, a fascinating jewelry design, or an interesting box for dispensing something, it can be covered by a design patent, and it protects the ornamental aspects of that product. Jewelry designs are often patented. Unique furniture is often patented. And then we're skipping on here. Let me, I guess the utility patent is the last. Let me go back here if I can. All right. Technical difficulty, bear with me. All right, so why am I having this trouble? Okay. All right, so last but not least, patents. The pro of patents is they do not require you to prove that someone had access to your invention or that they even copied it. As long as your product development or technology has been taken by somebody, even accidentally, you're able to enforce your rights. As far as an asset, it's something that investors understand. A utility patent, goes right potentially to your business because it covers your products that you've commercialized, it covers your processes that you've commercialized. So it has direct value to your company. I guess the disadvantage is that it does take a while to obtain one. There's a lot of back and forth with the patent office sometimes, but at the end of the day, you have a very nice intangible asset. It lasts for 20 years. So, that's my overview. My next slide really is just sort of to open it up for questions at this point and say, okay, there are different kinds of intellectual property. When you get it, what products or services you should cover with it depends on your circumstances. You have new product developments. What does the market landscape look like for you? How important is name recognition? Are you in software? Are you in hardware? Are you in the United States? Are you thinking globally? All these are sort of factors to consider when deciding what makes sense for you. And at this point, I've sort of given you some background. I'm happy to take general or specific questions if there are any.
I'm gonna give everyone a second to pop up if they're interested in coming on camera and things like that. So sometimes helps to give people a minute. I just sent a message in the chat too. Does anyone have a question right off the bat? Because I have a few that we've heard from startups and just like our ecosystem over the last couple of months. But I'm curious to say, again, who here has questions or even thoughts that they want to discuss with the group. See Stan on camera, Christine on camera. I'm not sure if anyone else here is going to pop up. Normally we have more people who are showing their faces so we can say hello.
They're at the beach. They're at the beach. That's why.
Stan, yeah, they're really. Go right ahead. Thanks for joining us.
So,
and you're not at the beach, Stan.
it's Stan North. In your discussion of trademarks and design patents, where do you fit McDonald's Golden Arches?
That's a trademark.
And so it has all the advantages of nobody can copy the Golden Arches. It goes on forever. It gets the benefits of the Lanham Act, triple damages, attorney's fees.
Well,
and why wouldn't you always try and take your design and trademark it as opposed to a design patent?
well, that's a good question, Stan. They go toward different, things, I guess. The design patent, especially if it's for let's give an example of a Vaseline intensive care lotion bottle. There was a big lawsuit about whether the green Vaseline intensive care bottle could be the subject of something called trade dress. That's what you're talking about. That's a sort of a trade dress is sort of a hybrid between a typical trademark and a design patent. in order for sort of ornamental shapes like that to acquire the status of trademarks, like the golden arches, they need to do something called acquiring distinctiveness. And they're always at risk of sort of losing their distinctiveness if there hasn't been enough investment in advertising dollars, if it's not recognizable by the general public. So you'll see, distinctive trade dress like restaurant decor. They try to register that, but it can be very difficult and can take many years, and you have to show that you've advertised it a lot. A design patent is a little bit more like industrial design. So if I have a neat, display sign that has particular curves in this direction or that, you're not going to think about a company, but people are going to want that ornamental aspect of the display sign. So it's not really identifying McDonald's per se. It's just a neat design. It's a neat piece of jewelry, for example. You're not going to associate a neat piece of jewelry necessarily with a particular jewelry maker, but you want that to protect it.
Is it litigated kind of the same way as a maybe a trademark? And is a design patent litigated kind of the same way? Of I have you've patented a design, you have a design patent, and I have something that is not a design, it's not your design, but it's the form. It's
right.
Close there. It's 5 letters. 3 of them are different.
Right. The answer is it depends on the circumstances, and what's easier, what's not. But in general, it's easier to enforce a design patent than it is to enforce trade dress, because there are a lot more, mushy factors to establishing that you've acquired distinctiveness to the shape of something. Whereas if you're on the trademark side, if you've asserting design patent, the test is very simple. Would the ordinary observer find the accused design to be similar to the registered design patent? It's a much simpler test. So I would say it's easier to litigate a design patent.
Thank you.
You're welcome. What are you? Are you in an emerging growth company, Stan, or are you an advisor?
Forgive me, I have a annoying background sound that should stop in a second.
Oh, okay.
No, so I'm sole proprietor, but I have a portfolio of 10 different companies that I act kind of as general counsel for.
Oh, all right.
So one hot topic is large industrial companies such as 3M, which have run out their patents. The first respirator was patented back in the 1920s. So what do you do today? Well, they're filing design patents. Look how ornamental, look how unique face mask looks like. Of course, it's made with the same materials, it's made the same way, it does the same thing. And for startup companies who are going into the market to make respirators, assessing the risk that someone says, your red parasol looks a lot like my yellow beach umbrella, so they're the same. So you're infringing my design patent.
Well, I mean, you hit the nail on the head there. That concern that there's an issued design patent out there and requires, a competitor to look carefully at that is why a design patent has value. It's having the chilling effect that I talked about. People are, I guess one thing that I didn't mention, I guess, is design patents and trade and utility patents. In order for them to be valid, they have to be new and not obvious from what has come before. So to the extent a respirator mask similar to one that's the subject of a design patent was already in existence well before that design patent. Again, it's a case-by-case thing, but those older designs, if they're identical, would potentially call into question the validity of a design patent. That's why I guess some advice I give to startups is if they can see their way in as a line item in their budget, they might, before investing in pursuing a patent, it's often worth doing a patentability search to see what has already been, put out there, and what might present an obstacle to a company obtaining a patent because of so-called prior art that are already out there.
I don't want to interfere with this question, but after you answer her question, I have a follow-on.
Sure.
Go right ahead. Can finish the conversation. I'll get on to it.
So the process of before building a plant, let's have a patent lawyer look at the patent field out there, the landscape, the patent landscape, and have a useful opinion that this design patent to an ordinary observer would, your design, which looks like the 1925 patented design, would, to an ordinary observer, not be confused with the golden arch design of a company like 3M. That
Right.
same process would be useful and customary.
Well, among the services that patent lawyers provide are reviewing patent landscapes, like you're saying, and taking positions or rendering legal opinions as to non-infringement, which is what you're asking about. They also can render opinions as to invalidity or validity. They also, I guess, one of the most routine ways that startup companies encounter patent lawyer opinions is they'll ask whether something is patentable. So there's a patentability opinion where you look at, I got this invention, is it patentable over what's come before? That's another kind of opinion. Larger companies do these things called freedom to operate. I've come up with this device and I want to make sure that no one's going to claim that my product, when I commercialize it, infringes other people's patents. That's a slightly different search. So yes, Dan, if it helps avoid or increase assurances that a contemplated course of action by a business isn't going to put them in hot water, it's worth investing in an opinion. It helps show that the businessman acted prudently, so that if, God forbid, there's a dispute afterwards, despite the opinion, the fact that you took precautions to make sure that there was no issue shows that you're a good, reasonable business person and helps you out of that kind of a dispute. An opinion, though, no opinion can, the problem with opinions is they're worthwhile, they increase assurances, but you can't predict how unreasonable the owner of the patent's going to be. They sometimes will take an unreasonable view as to what their patent covers. And you can't predict that.
Would you comment on the use of an opinion in your file or this search, even if it doesn't rise up to an opinion? as to subsequent, the subsequent landscape if someone's suing you for intentional infringement and seeking treble damages.
Right. No, that's what I was mentioning. It's again, this isn't legal advice because I'm not sure of the particulars, but
Of course.
as a general proposition, opinions are used to show that you as a business person made a careful decision, and so your infringement was not, reckless, willful, or any of those adjectives that could lead to enhanced damages. There's case law that has actually recently made those opinions, potentially more valuable. But it's, again, one piece of evidence that the court will look at in deciding whether the businessman behavior is business person.
Again, thank you.
No problem. Sounds like you're busy with, if you're dealing with 3M, they have one of the largest patent portfolios there is.
Yeah, that does sound like quite an undertaking. I have one or two questions of my
Sure,
own,
Kathy.
but we also got a question from the audience asking about if there's a particular timeline that you recommend for startups who are registering for intellectual property. And if along that timeline there are specific clauses for getting those approved in like a timely manner. Is there some sort of step-by-step? Can some things happen in parallel? What's the timeline look like for even establishing intellectual property?
All right. I mean, well, it depends. It depends on what sort of intellectual property. So I'll answer in a couple different ways. I mean, there's a couple, big caveats that I would give to, and some of this, again, is second nature. I'll start by saying, just because you were able to get your company name registered in whatever state that you choose to incorporate in does not mean that your clever name is available for use in commerce with your whatever goods and services you contemplate. So in corporate databases usually are sort of identicals only. If there's a slight difference between your company name and another, you can get it registered, but there might be a substantially similar person using your name in substantially similar goods, and you find out about them once you have started making money and they write you a nasty letter. So in terms of timing, I recommend a trademark clearance for whatever name you are contemplating using in commerce before you fall in love with that name. That's the timing there. As far as patents, in order for you to maximize your patent rights worldwide, you should file a patent application before you first offer your invention for sale or otherwise commercialize it. If that's not practical and all you really care about is the United States, the United States gives you a 1-year grace period. So I guess what I'd say is, don't come thinking how great it would be to get a patent on your invention after you've had it on sale for a year, because it's too late by then.
Yeah.
Um,
Do you recommend sort of right away, like you process that trademark clearance and immediately try to file whatever intellectual property you can while you've
for
done
trademarks, yes. For
Yeah.
trademarks, you
Trademark.
should do that. In fact, it's even easier. You can file a trademark on the basis of so-called intent to use. You don't have to start
Right.
using the trademark.
Right.
So if you just like a name,
And you're just like building, you can at least file some of the trademarks while you're still building and working on it.
exactly.
That when you go live, at least you're protected in that sense.
You have up to 2 or 3 years to actually start using a trademark that you've registered on the basis of intent to use.
Got it.
So it's certainly worth doing trademark work upfront. It's fairly inexpensive too.
Okay.
I saw a philosophical question come up.
I know. Do you want me to read it to you? It's quite long. It's amazing. I'm going to read it for the whole group in case I didn't say. An almost philosophical question from Todd Gibson. Is the concept of patents and copyrights on its way to becoming obsolete or unenforceable? It takes a long time and requires much money to secure a patent, and protecting it requires even more resources. Decisions are basically made on a subjective basis. Are they worth it? Although not a patent case, consider the case against Led Zeppelin for stealing the tune that became Stairway to Heaven. It was litigated for years and was decided both against and eventually for Led Zeppelin after the death of the plaintiff. The expense of the case was huge, and the verdict was ultimately a subjective call by a judge.
Right.
Thoughts, being that this is your profession?
Right. No, I think that's a great question. No, I think the judicial system for most people in all areas should be reserved for significant disputes, because the judicial system requires an expense to activate. It takes time, and this is across the board. This is for any dispute. And you know, subjectivity can invade commercial contract interpretation, interpretation of insurance coverage claims, personal injury. There's always a risk of subjectivity. It's one of the reasons why I guess, you know, there are juries which have their own risks, and a judge who is improperly subjective presumably would be overturned on appeal. If the nature of the dispute is not significant enough, it's not worth going to the time and expense of litigating it. Back to the worlds of patents and copyrights, I guess only 2% of patent disputes ever go to the point of preparing for trial.
Oh, wow.
So I guess the message there is your dispute sort of finds a way to resolve itself consistent with the amount of money that's on the line. Stairway to Heaven, and in that case, there must have been an awful lot of money on the line to justify that. And businessmen are making, you know, the call as to whether it's worth investing in a lawsuit or not. Patents have a way of keeping disputes from going to court, in the sense that there's a document that has been vetted by an administrative agency. It's presumed valid, and there are a lot of avenues to come to terms with someone who accuses you of infringement. That there's a lot of ways you can design around a patent. If anything, I think patents is one of the more predictable areas of law. So I don't think it's going to become obsolete or unenforceable. We have mechanisms to flush out bad patents that allow you to save a substantial amount of money. So let's say, for example, someone gets, back to your case, Stan, so let's say someone gets a patent, a design patent or utility patent, and it should never have been granted. Instead of having to go to court and spend hundreds of thousands of dollars, the patent system allows you to use administrative procedures to explain to the patent office, hey, this patent was incorrectly granted. It should never have issued. Can you take another look at this? And those are procedures that, you know, much more efficiently than what Led Zeppelin did, much more efficiently can resolve issues.
Mm.
So I'm a big fan still.
Do you think the recent sort of globalization of communication, leveraging, Zoom meetings, talking all over the world, social media, like just the ability to broadcast a lot more widely has impacted either patent litigation or intellectual property filings or complaints? And now that there's so much that's on the internet, has that changed how certain intellectual property is either protected or potentially either stolen?
I think that's an excellent question. I mean, the world of patents has been global for a long time, but it went especially global in the United States about 10, 15 years ago, when there were some changes to, I guess it was more like 5 years ago. There were changes to the Patent Act that recognized that international publications, international developments are potential, if they've come before developments in the United States, even if it wasn't a development in a foreign country, if it preceded the one in the United States, it rendered that patent invalid. So patents are a global undertaking. Zoom and these connectivity platforms have just made the availability of these sort of global technologies easier. So it's easier to look at a patent and make sure that your patent is valid, or it's easier to invalidate a patent.
Right.
That's happened in another part of the world.
I would imagine right now, there's 9 patents. Like, it's possible, 10 years ago, someone in California and someone in New Jersey could have been selling the same item that they thought was theirs. And now with like social media and Zoom and having more be on the internet, like, I'm just wondering, like, has it ever happened where 2 people are producing a very similar item and like neither of them has filed a patent, but they come to find out that there's someone else out there now, through social media, through an e-commerce website, that's
Right.
something similar. Like, what do you do in that instance if like my Jasmine's necklaces are actually the same as someone like on the West Coast? What is, like, do I just immediately then run and try to file anything before what they're doing like is also filed? How do you protect them if you don't?
Well, you can't. You only had a year. Well, it depends on the answer is, I don't think the tail wags the dog. I think the commerce will go on. It's fairly common in the trademark world, for example, for similar marks to bump into each other when they start expanding their territories. The internet makes that simpler, but unless there's a substantial negative effect on your commerce, usually people will wind up competing in the marketplace. They can't run and file a patent usually because they had only 1 year to do that, right?
Yeah.
If it's a question of a trademark, again, there might be a discussion or a fight over who was first and where, but there's been law on the books about trademarks for many years that say, hey, if you were a local user in California of this mark and on this date, and I was a local user in New York on that date, we can't stop each other from our local use.
Right.
If we decide later that we want to expand into your area.
Right.
Your prior use can continue and you're not going to be able to stop it. So to the extent the internet highlights and causes people to bump into each other, I guess some more letters have been written between lawyers. We've had some folks that uncovered people for the first time on the internet. They ask us, hey, can we stop them? And I said, is this person really interfering with your business, causing confusion? That's the real test. No, they're not really causing confusion. Everybody knows we're here and they're there. Okay, well then, carry on.
Yeah. You mentioned, and I think everyone thinks about the recipe for Coke, right? When they think about intellectual property, I think that's probably the first thing most people come to mind. In the tech, I don't know if you've ever noticed this, but the color blue shows up almost every major tech company. Like they've got their own shade of blue, and it's synonymous oftentimes like with their name. Like there's a Twitter blue, a Facebook blue, a LinkedIn blue, you know, and I'm wondering if now the trend is like a hex color or a actual like pigment of a specific color that companies will copyright or trademark in association with their brand. And how that works if another company has one shade off. Like, is that a, like, how does that work?
No, I mean, the ability for color to function as a trademark, again, it's been around a long time. You're right, it's become so important now that there are Pantones, exactly. Someone mentioned, thank you.
You just said the Pantone, yeah. Tiffany
Right
Blue.
now, the trademark office looks at Pantones to decide, you know, how similar things are.
Yeah.
But the trademark office tends to be, you know, a little skeptical about color as a trademark. One of the oldest cases was this case about dry cleaning press pads that were a particular color, and when they sold their dry cleaning press pads, they wanted to be the only ones that had this color press pad. Again, you have to establish that the recognition of that color has acquired distinctiveness for it to start functioning as a trademark.
Right.
It requires 5+ years of substantial advertising investment in the color.
And I just have one question, and I want to remind the audience, you know, we've got about 15 minutes left, so if you have other questions and you want to put them in the chat, pop back up. My last question is that, you know, I got your presentation in advance, so I took a look at it, and there's obviously many types of intellectual property. Do you typically recommend that companies work towards having a few of them? Like, it sounds like trademarks plus maybe copywriting plus patents. Like, do you find that most organizations have more than one type of intellectual property?
Yeah, they're not mutually exclusive, and there can be overlap depending on the circumstances.
Okay, cool. Yeah, I figured as much. Looks like Stan just popped up. Not sure if you have another question.
If I may intrude, and maybe others will find it of interest as well. So an N95 respirator is something you can hold in your hands. You can look at it. You can look on the box, you know, patent pending or not. You know, it's more definite and understandable at a glance or two or three. The machinery to make one is often American or German design machines that have been taken offshore, read into that China, modified in ways that the original producers of that machine don't really follow or would like to follow but are kept from following, and are now being reoffered into the American market. And it's, you know, just think of a 100-foot long, 100 feet by 12 feet high by 8 feet across, series of linked up machines of all kinds of different makers and designs, and out pops a N95 mask. The patent exposure, you know, who knows whose invention. If I'm buying the machine, I assume I have a lot of protection because I'm buying the machine, and whoever has a patented component to it, in theory, has been paid for the use of that patent going through. But you know, they made, you know, the offshore design may say, oh, here's a good idea someone in America has found. Let's incorporate that, and it's actually a patented improvement, but it's You know, it's not on the box label of a patent or patent pending. And it's an exposure. And it just seems to be an interesting, the example of an elephant, people holding the leg think it's one thing, people holding the tail is something else, people holding the trunk. Any insights as to that process of evaluating the risks there?
Well, I'm going to talk generally about it, and Stan, I invite you to contact me offline if you want to talk about more particulars. A couple things that, I liked your scenario because it had sort of the international aspect like Jasmine was mentioning. So I want to talk a little bit about that. And it talks about, what sort of guarantees can you have when you get a machine that you're going to be free to use it the way you wish. So, first and foremost, a U.S. patent to a machine or to an improvement to a machine that's issued covers, prevents, an unlicensed third party from making, using, or selling the invention, in this case, the machine, or importing the machine into the United States. So if a Chinese supplier imports into the United States a machine covered by a U.S. patent, that act of importation itself is an infringement. If someone purchases a patented machine, it depends on the terms and conditions of the sale, but if there's no agreement that the seller is assuming the risk of infringement by operating that machine, and if the agreement is silent, the conventional rule, the default rule under contract interpretation is that the person who sold you that machine is responsible for it to not infringe other people's rights. So you as the purchaser, have recourse to the person who sold you the machine if there's ever a problem of infringement. And again, we've often had this sort of situation, and I guess one of the reasons it's important to buy from reputable suppliers, because you want them to stand behind their products. One of the ways suppliers stand behind their products is they help you out if there's a problem with operating the machine because of some third party claiming that there's an interference with your being able to operate because of some patent. I guess the last point I would want to make about this is, if you buy a machine from a manufacturer and that manufacturer has patents on that machine, that doesn't matter. You're free to use the machine in any way you want. It's called patent exhaustion. In other words, once you, again, absent particular circumstances that might be in contract language, you are free to use a machine for its intended purpose, even if the supplier has patents on that machine, because the supplier, when he sold you the machine, expected you to use it for those purposes and basically granted you a license under any patents to use the machine. So there should be no issue there either. That's a little more technical, but I cover that.
So I have a question. Can you hear me?
Hi, Christine.
Hi. So I work with a lot of small businesses on regulatory issues, and one small food company, actually, it was an outgrowth of a graduate study program, and they received a National Science Foundation grant for the process and the technology around doing something really cool with, let's say, I don't know, garbanzo beans. But they're being advised to go for a patent, but they're worried because they feel they're going to expose too much of their technology and too much of their process, and that they have no means of defending that while it's in process. So how do you work with small businesses who do have a unique design or a unique technology or process? Are they vulnerable during that process? And is there anything the government or anyone else can do to protect them during that time?
Well, yeah, let me talk about that. It's a very good question, and it's one that comes up a lot. I guess first of all, there's another related question, Christine. I don't know if this is the case, but let's assume the patent eventually issues that you're talking about for your process. A question I would ask up front to this person, this company, is, are you going to be able to detect whether a competitor is using your patented process at all? And if the answer is no, at no point in time, either after the patent is issued or before the patent is issued, will we ever really know.
It's the first of its kind, and it does something to the product that is not seen in the market today, right? So,
well, then, I mean, I don't know if you were, one of the things I said at the beginning is the question of whether to keep something a trade secret versus patented is exactly the issue that you have right there. So if you're confident that no one's going to be able to figure out your process by reverse engineering from the garbanzo bean or whatever it might be, the canning process, then you're confident you can maintain a trade secret, and that trade secret will give you the market advantage you're looking for without exposing the technology to the publication that occurs with a patent.
sure. But
Now,
what if you can't? What if it is a patent-worthy process?
all right, so getting back to that example, patent applications remain confidential until they're published. They're generally published about 18 months after their filing date. But you are right that most patents take 2 or 3 years before they issue. So there's a period of time where people will potentially see the invention and be able to copy it to your detriment. Good news is that there already is laws in place to address this issue. It's called provisional rights. And what that says is, even if you can't sue someone because you don't have a patent yet, if and when you get a patent, assuming it looks a lot like the patent that was published at 18 months, you're allowed to seek damages and enforce your patent against that infringer from the moment of publication. And now again, there's a lot of analysis that goes into whether the patent that was published looks substantially like the patent that you got. So that's a question right there. But that's some attempt to address your issue.
Okay. But there is exposure for a very small company versus a very large company in that process, in that time frame. Yeah.
There is.
Okay. All right. Thank you.
Is there, you mostly answered this, I know we have just a couple minutes left, but are there certain other like government resources or ways that a company can like develop additional protection as they're going through this? Todd asked a question about USPTO's biggest weakness area of need, and I don't know if that might tie into this, because what Christine just mentioned seems like a weakness in this process for the small businesses. And I'm wondering if these are separate, or if you think that might be a weakness in the process.
Well, I'm sorry, Jasmine, go back. What was the issue that you said might be a weakness as well?
I was just wondering if you thought the vulnerability of small businesses is a weakness that there could be additional government processes for or legal protection for, and if that's either separate or can be discussed in the same answer to Todd's question about the US.
I mean, I think based on my experience with the US Patent and Trademark Office, I think the frustration that some of my emerging growth companies express to me is how there's a certain skepticism and bureaucratic inertia that prolongs the patenting process. And every time you have to go around with the examiner of the patent, again, adds cost to the process. And I've actually just filed an appeal brief citing this exact issue, which is, you're supposed to sort of tell us all the prior art that's available that's going to cause an obstacle so we can talk about it all at once. So what they do sometimes is they tell you about it, and then they tell you a little bit more separately, and you wind up with a non-compact process. And that there are tools. The fees are reduced for small entities, but the legal fees aren't reduced for small entities. If you have to do an office action, it's still going to take time.
Right.
So if there were one area that I'd like to see improved, is I'd like to see a little bit more recognition that when an examination is taking place, don't redo it unless there's a really good reason to do it, because it adds expense to a startup business. Having said that, I would also say that small businesses need to be aware that they should put in their funding request a line item for intellectual property. So, and it should be a reasonable line item for their patent. It's an important investment, especially at the outset.
Yeah.
All right, well.
That was good advice to end with today. Thank you for joining us and for answering all these questions and really diving in deep with us today.
Thanks for all the great questions, and thanks for the opportunity.
Well, thank you all to everyone that tuned in. Richard, thank you so much again. And we will, of course, be sharing the video later in case anyone wants a recap. If anyone wants to connect with Richard, I'm happy to introduce. And we'll go from there. Yeah?
Have a good afternoon, everybody.
Cool. Have a great one, everyone. See you soon. Bye.
Jasmine, how do we connect with you?
Oh, my email is Jasmine, JASMINE @techunited.co. Just put it in the chat too, in case anyone wants to get connected.
There you go.
Okay.
All right. We'll see you all soon and have a great rest of your week.
Thanks
Thank
again.
you all.
Thanks, TechUnited.
Bye.
Take care.